This video is going to focus a bit on how the Supreme Court actually selects the cases that it does. All right, first things first. It's important to know that in a Supreme Court case, we don't have prosecution and defense. We have what are called petitioners and we have what are called respondents. So, where you are in relation to the V in your Supreme Court case determines if you are a petitioner or a respondent. The petitioner is always to the left of the V, and the respondent is always to the right of the V. So a petitioner is the side in the dispute that lost in the most recent court to hear the case, and they are petitioning the Supreme Court to accept the case on appeal so that the Supreme Court can undo the most recent court's ruling. If you are to the right of the V in a Supreme Court case, you're what we call a respondent. You won in the lower court, and you either don't want the Supreme Court to take your case because, hey, you won, or if they take your case, you want them to make the same decision the lower court did because you won, right? It's important to know that the Supreme Court has complete control over what cases they want to hear. You have a right to appeal your lower court decisions. You don't have a right to appeal to the United States Supreme Court. So over here on the left, these individuals are all standing on the steps of the Supreme Court at former Justice Ginsburg's funeral. Every Supreme Court justice, each of the 9 of them, has around 4 clerks. Clerks are like interns. These are the best law school graduates during the course of the year from schools like Yale, Princeton, Harvard. They apply basically to intern with one of the judges, usually for about a year. They do a lot of the research for the judges. And again, they do this for about a year. They are responsible largely for going through many of the thousands of cases that are appealed to the Supreme Court every year. It's not the individual judges. They don't have the time for that. So maybe a judge, tells their clerks, I'm really interested in hearing a case about gender discrimination this year or First Amendment rights involving students. So it's the clerks that go through the case piles and they will give some of those types of cases to the judge that they work for. And then if you look at the picture on the right, once a week, typically throughout the year, the 9 justices sit in this nice posh office in the Supreme Court, and they take turns arguing over what cases they should accept to hear in the next year. Every judge basically makes a pitch about what cases they should hear and why, and then they ask for a vote. It's called a rule of 4 because it takes 4 of the 9 judges to agree for them to formally accept the case. So again, the clerks go through the pile, they give them to the judges then make arguments about what cases they should hear, they take a vote amongst the 9 judges, and you need at least 4 to agree to accept the case. Once the Supreme Court agrees to take the case, they issue a formal legal document called a writ of certiorari. This is an order to all the lower courts that have heard the case previously to send up all their files related to a case. To the public and to the people fighting in a case, this is how we know they've agreed to take a case. Is when once this writ of certiorari is announced and is sent to the lower courts, we know that the Supreme Court, has agreed to take on a case. And I know the dates are a little outnumbered on this, but if you look, there are thousands and thousands of cases appealed to the Supreme Court every year. In a busy year, you're probably looking somewhere between 70 and 90 cases the Supreme Court would take. So again, the Supreme Court has complete control over what cases they want to hear. And it's important to know that most cases are not going to be accepted by the Supreme Court. Whatever lower level court, whether it's the Court of Appeals on the federal side or the state Supreme Court on the state side, whenever court heard this before the Supreme Court, if the Supreme Court does not accept the case, the lower court's ruling just stands and the Supreme Court declines to hear the dispute.